I was having dinner recently with a friend who works in international arbitration, one of those people who spends his life reading the fine print of global treaties. He was unusually animated, describing a recent meeting in Brussels regarding the new 90 billion euro loan to Ukraine. He called it a legal masterpiece, a way to fund a conflict using frozen Russian assets as collateral without technically seizing them yet. He was genuinely impressed by the linguistic gymnastics involved, painting a picture of a unified Europe finally finding its teeth and its wallet at the same time. But as a coffee arrived, I asked him how he'd feel if his bank allowed a total stranger to take out a massive line of credit using his own family home as security simply because the bank directors didn't like his behavior. The atmosphere at the table shifted instantly. The professional polish dropped away, replaced by a look of profound unease. He leaned in and admitted, almost in a whisper, that behind the triumphant press releases, a specific kind of panic is starting to set in. He told me about the silent army of top-tier lawyers Russia has spent the last 2 years recruiting legal sharks who don't care about ideologies, only about the cold fact that you cannot legally pledge property you do not own. That moment of realization, the gap between the giddy excitement of the headlines and the terrifying reality of international law, was jarring. We are being told this is a clever way to save the European economy from the costs of war. In reality, it looks more like a desperate, high-stakes gamble that ignores basic mathematics and legal precedent. It is a logic that assumes we can rewrite the rules of global finance on the fly without anyone calling our bluff. As the EU prepares to issue bonds that no rational investor might want to touch, and as capital begins to quietly leak out of the continent, it makes you wonder, are we watching a bold strategic move, or are we witnessing the final frantic tremors of a house of cards about to collapse? Okay, let's unpack this. The core question, as that conversation highlighted, is about a massive legal and financial gamble. Using immobilized Russian state assets, particularly those belonging to the Central Bank of Russia, or CBR, to fund Ukrainian recovery and defense. And the detail you sent us, it really focuses on this crucial distinction between freezing, confiscating, and this new, almost radical idea of temporary management to secure a massive loan.
It's fascinating, isn't it? The sheer scale of the legal and political tightrope walking necessary here is just, well, it's unprecedented.
I mean, we're talking about huge sums.
Huge. We are talking about immobilizing around 210 billion euros of Russia's sovereign assets, and then separately freezing about 28 billion euros of private assets.
From sanctioned individuals.
Exactly. The goal, it's clearly about securing reparations for Ukraine, forcing Russia to ultimately pay for the immense destruction. But the mechanism they've chosen, this proposed EU instrument, the so-called reparations loan, it just reveals the deep systemic legal risks the EU is trying to navigate.
Especially around this foundational principle of state immunity.
It's almost a sacred principle in international law, and they're walking right up to the edge of it.
Okay, so let's start with the basics for you listening, because the terminology the media uses is often a little sloppy. Legally, these terms are worlds apart. So when we talk about these Russian assets, what exactly is the difference between them being frozen, immobilized, seized, and confiscated?
That distinction matters profoundly. It defines the legal room the EU has to operate and, how much trouble Russia's silent army of lawyers can really cause.
Okay, so let's start with the big one. Assets.
Right. Assets is just the broadest term. It covers everything with economic value. Cash, investments, property, and, this is critical in this case, financial instruments.
So things like government bonds?
Exactly. The bulk of the money we're discussing is government bonds or currency reserves that the Central Bank of Russia holds in these places called Central Securities Depositories, or CSDs. The big one is Euroclear in Belgium.
All right, so what about freezing? That's the word we hear most often.
Freezing is the standard temporary measure. It's a sanction. Think of it like hitting a pause button on a bank account.
Okay.
It provisionally limits the peaceful enjoyment of property rights. So it prohibits any transfer, disposal, or movement of the asset. But, and this is the key point, freezing does not affect ownership.
So the owner still legally holds the title?
Precisely. Your bank account might be frozen, you can't use the money, but it's still legally your money.
So if the 210 billion of CBR funds aren't technically frozen in that broad sense, what does the term immobilized assets mean, especially for those funds sitting at Euroclear?
Right. Immobilized assets is the more technically precise term they prefer for sovereign central bank assets. It means the assets are operationally prevented from being transferred or settled.
So practically locked in place.
Exactly. It preserves the asset where it is, while ownership remains completely unchanged. It's a narrower restriction than a full asset freeze. And the EU has applied this term specifically to that huge pot of CBR assets, the 210 billion. They're essentially locked away in the vault, with Russia still holding the deed.
Okay, so that's freezing and immobilizing. Now let's get into the more aggressive terms. Seizure.
Seizure is a step up. It's a compulsory taking of possession or control by a competent authority. This is usually in criminal law, often to secure evidence or, recover the proceeds of a crime. It's an act of taking control.
And finally, the one everyone thinks is happening, but isn't, at least not yet, confiscation.
Confiscation. That's the big one, the permanent and final deprivation of property. Legal title is conclusively transferred to a third party.
Without consent, without compensation.
Without either. It's a very severe measure, usually ordered by a court after a criminal conviction. It means the ownership legally changes hands forever.
And that distinction, that temporary immobilization versus permanent confiscation, that's why my friend called the EU's plan a legal masterpiece.
It is, because proposals for outright confiscation of the principal 210 billion have just run into an almost impenetrable wall.
A wall of international law.
A massive wall. Achieving permanent title transfer requires overcoming huge legal and political hurdles.
Okay, so recognizing how difficult that is, the EU has focused its immediate efforts on two less contentious areas, right? Private assets and these so-called windfall profits.
Exactly. They've made significant, actionable progress there.
So let's start with the private side. We're talking about the yachts, the properties, the bank accounts of sanctioned individuals. What has the EU actually done there?
Well, they've introduced new directives, specifically 2024-1226 and 2024-12260. These are aimed at strengthening the ability of member states to actually act.
How so?
They define criminal offenses for violating sanctions, so it's now explicitly illegal to try and get around the freeze. And they significantly enhance asset recovery and confiscation mechanism.
And I read they're setting up special offices for this.
That's right. They're establishing asset management offices in the member states. Their job is to make sure frozen property doesn't lose value, and in some cases, to allow for the sale of assets that might depreciate quickly, like a car, or are really costly to maintain.
But the proceeds are still held, right? They don't just go to Ukraine.
Correct. The proceeds are held pending a future legal resolution. But, and this is the huge practical limitation,
It's not enough money.
not even close. Even if the process works perfectly across all 27 member states, the total amount of funds they expect to confiscate from these private assets, even the full 28 billion euros, is just insufficient.
I mean, Ukraine's reconstruction needs are in the hundreds of billions.
Exactly. And success depends so heavily on the judicial practice and efforts of individual national courts. It's a very long-term, piecemeal process.
So they shifted focus to these windfall profits. This is the truly novel part, the mechanism that's actually started to generate cash. How are these profits generated, and what makes them legally different from the principal?
Okay, so the windfall profits, or extraordinary revenues as they're officially called, are the profits generated by the immobilized CBR assets, the ones sitting at Euroclear.
So Euroclear holds this massive 210 billion euro sum.
And it reinvests the cash balances that mature or are generated from coupons and interest payments. And in a high interest rate environment, that earns a significant yield.
A lot of money.
A lot. And the brilliance of the EU's move was to legally separate these new earnings from the original principal assets.
What's the legal argument for doing that?
The core argument is that these new interest payments are not sovereign property in the same protected way as the original reserves. Therefore, they don't benefit from that same high bar of state immunity protection.
Interesting. And the initial plan for how to use that money was very telling.
It was incredibly telling. Initially, 90% of these net profits were allocated to the European Peace Facility, the EPF, to finance lethal weapons for Ukraine.
And only 10% for reconstruction.
Only 10% for the Ukraine facility.
But that allocation has shifted recently, hasn't it?
It has. After they established the Ukraine Loan Cooperation Mechanism, or ULCM, the priority was adjusted. Now, 95% of the proceeds go directly to reconstruction programs through macro financial assistance loans.
So they're prioritizing financial stability over immediate military aid now?
It seems so. Only 5% still goes to the EPF. It's a clear shift from immediate military aid to securing long-term financial stability, both for Ukraine and, frankly, for the EU's own balance sheet.
That shift is fascinating. But going back to that initial choice to use the EPF, was there some political maneuvering involved there, given the internal divisions in the EU?
Oh, absolutely. The internal politics were incredibly complex. The EPF, which is an off-budget instrument financed by member state contributions.
So it's outside the main EU budget.
Correct. And it was initially used strategically to circumvent one of the most persistent internal challenges, the political veto of certain member states on funding lethal aid.
You mean Hungary?
Specifically Hungary. Their tactic has been what's called constructive abstention on EPF decisions about weapons and these windfall profits.
How does that work?
Well, because Hungary abstained from the Council decision back in May 2024, the legal interpretation that Belgium put forward and the Council accepted was that Hungary arguably forfeited any legal claim over how those specific funds were distributed.
Wow, so they found a procedural loophole.
Essentially, yes. The EU found a way to authorize assistance measures under the EPF without needing Hungary's explicit vote of approval. It stabilized the financial channel despite the ongoing political obstruction.
Okay, so now we get to the main event. The 210 billion euros in principal CBR assets. This is the massive pot of money everyone's after, but it's protected by this fundamental concept, state immunity. Why is this such an impenetrable shield that it forces the EU into these elaborate legal gymnastics instead of, just taking the money?
Well, the shield isn't just legal, it's systemic. It's rooted in the foundational architecture of the modern nation state.
The idea that all states are equal.
Exactly. The principle of sovereign equality, summarized by the Latin maxim par imperum non habet imperium, an equal has no authority over an equal. If France could just seize Germany's assets unilaterally, the entire system of global finance and diplomacy would just collapse.
So one state can't drag another into its courts without consent.
Right. But it's not just about judicial processes. What's most relevant here is immunity from execution or enforcement. Authorities of one state, or an organization like the EU, are precluded from taking measures of constraint against the property of another state.
And how does that apply specifically to a central bank? I mean, is managing currency reserves a sovereign act, or is it more like a commercial one, like running a big bank?
That's a critical distinction. The difference between acts of sovereign authority, acte iuri imperii, and commercial dealings, acte iuri gestionis.
And central bank assets fall into which category?
Overwhelmingly, the first one. While some government assets used for commercial trade might lose immunity, the vast majority of international legal practice views central bank assets, currency reserves, government bonds, as protected.
Because their management is seen as an exercise of sovereign authority for a non-commercial purpose.
Exactly. They are critical to the state's financial stability and integrity. The predominant international practice is to grant central bank assets absolute immunity from execution in all circumstances.
That's a very robust protection.
Incredibly robust. It's codified in customary international law, reflected in treaties like the 2004 UN Convention on Jurisdictional Immunities. That's precisely why outright confiscation of the principal is so fraught with legal risk. Any action that permanently transfers title would violate this bedrock principle and trigger massive international litigation.
So if the CBR assets are virtually untouchable, how does this proposed EU instrument, the reparations loan, claim to bypass this? I keep coming back to that dinner analogy. How do you convince someone you can legally pledge their house as collateral without owning it?
This is where the legal architecture earns the label masterpiece, or perhaps legal sleight of hand. The proposal is designed to be the most viable legal option because it meticulously avoids outright confiscation. It frames the action as temporary, reversible management of the assets, and it links it explicitly to a legitimate international reparations mechanism.
The whole structure is built on avoiding the word confiscation.
Entirely. The overall proposal involves 5 carefully designated sequential steps.
Okay, let's walk through them. What's step 1?
Step 1 is prolonging the immobilization. The restrictive measures that keep the assets locked up need to be secured using qualified majority voting, or QMV.
And not unanimity.
Not unanimity. That's a vital legislative maneuver aimed primarily at removing the risk of the required unanimous renewal every 6 months, a risk that countries like Hungary have repeatedly threatened to use.
Let's pause on that. QMV, qualified majority voting. For listeners, why is that such a decisive move compared to the usual unanimity rule?
Well, in this area, the common foreign and security policy, the standard is unanimity. That means one dissenting voice can paralyze the entire EU.
The single veto risk.
Right. QMV is a weighted system that bypasses that. To pass a decision, you need at least 55% of the EU countries, that's 15 out of 27, representing at least 65% of the total EU population.
So by moving the renewal of the asset freeze under QMV,
the EU ensures that even if Hungary or another state votes no, the decision to keep the assets locked up can still pass. It stabilizes the financial underpinning of this whole thing indefinitely.
Okay, so QMV removes the internal political veto threat. What's next?
Step 2 is the formal establishment of the EU instrument itself. This special purpose vehicle that acts as the reparations loan fund.
The entity that will issue the bonds.
Right. Then step 3 involves the actual transfer of money from the CSDs, like Euroclear. The EU instrument enters into a highly tailored debt contract with them, often at 0% interest for legal simplicity. And this contract allows the transfer of matured principal cash balances from the CSDs to the instrument.
But wait, a private company like Euroclear can't just transfer a client's funds, especially sovereign funds, without consent. How are they compelled to do this?
That brings us to step 4, which is arguably the most powerful legal tool they have. A decision under Article 215 of the treaty, which gives the Council the power to adopt restrictive measures, obliges Euroclear to make this investment.
So they're legally ordering it to participate.
Exactly. This decision grants a specific derogation from Euroclear's normal operational rules. It uses the EU's legal power to enforce a political decision, effectively compelling the CSD to transfer the cash balances. It transforms immobilized cash into a form of collateral guaranteed by the EU.
And then the final step.
Step 5. The EU instrument uses this compelled cash to issue a massive reparations loan to Ukraine. And crucially, the terms stipulate that Ukraine only repays this loan once it receives war reparations from Russia.
So it creates a shared responsibility.
It does. It ensures shared mutual responsibility for the EU and its member states, rather than leaving all the liability with Belgium and Euroclear.
This whole structure seems incredibly complex just to ensure the money is classified as management and not confiscation. Why is that temporary and reversible nature the absolute key to their legal defense?
It's the absolute linchpin against the state immunity barrier. The whole thing is designed so that ownership is not permanently transferred. The cash balances serve as blocked collateral.
Designed to induce Russian compliance.
Precisely. To induce them to comply with their international obligation to pay reparations. The defense is this. If the EU sanctions are lifted and Russia still fails to pay, Euroclear is guaranteed a claim against the EU instrument. The EU takes on the debt.
So the principal assets remain technically available for return?
In principle, yes, because the assets can, in principle, be returned to Russia at any time upon compliance, or if sanctions end, the EU argues they haven't violated the CBR's sovereign immunity. They're trying to check all the boxes required under international law for lawful countermeasures.
And that's the legal justification they're relying on, countermeasures.
That's the whole game.
Okay, so the underlying legal rationale for this entire controversial move rests on this law of countermeasures. What exactly are they, and why is the idea so contested when you apply it to sovereign central bank assets?
So countermeasures are defined under the law of state responsibility. They are actions that would otherwise be contrary to international law like seizing property.
But they become legal under certain circumstances.
Right. They can be taken by an injured state against a responsible state to achieve the cessation of an internationally wrongful act and secure reparations. Here, the wrongful act is Russia's aggression.
And the EU's justification relies on a powerful concept, the erga omnis argument.
Yes. Aggression is considered a breach of an erga omnis obligation, an obligation owed to the international community as a whole.
It's a crime so bad it hurts everyone.
That's a good way to put it. It undermines the entire global order. And because of that, the EU argues this entitles non-directly injured actors, like the EU itself or its member states, to adopt countermeasures against Russia.
Has that been tested legally?
The European Court of Justice has already leaned into it. They confirmed that sanctions against Russia responded to a violation of obligations imposed erga omnis by international law.
But even if Russia is violating international law, that doesn't automatically let the EU ignore the state immunity of the central bank. My friend's point remains.
Yeah.
Does the political justification override the legal immunity?
And that is the core legal sticking point. It divides international legal scholars into two main camps.
What's the first controversy?
The first is the legality of third-party countermeasures themselves. While state practice and legal literature are increasingly supportive of non-directly injured states acting to enforce these fundamental norms, like prohibiting aggression.
Some scholars are still skeptical.
They are. They question whether this practice is really established as fully customary international law.
And the second, more profound controversy.
That's the immunity versus countermeasures relationship. This requires a truly novel legal argument about how procedural rules, like immunities, interact with secondary rules like countermeasures. Can a justified countermeasure override sovereign immunity?
What's the traditional view?
The traditional view, based on rulings from the International Court of Justice, is generally no. The ICJ has argued that fundamental rules and procedural rules, like immunities, don't conflict. Because immunities are merely procedural. They don't pronounce on whether the underlying conduct was legal or illegal. Immunity is just the mechanism that prevents a court from even hearing the case, regardless of the crime.
So critics apply that same logic to countermeasures.
Exactly. They question if countermeasures can suddenly override sovereign immunity, which is designed to be a protective hurdle for all nations.
So the EU is essentially changing the rules of the game after the other side has already broken them.
That's the Russian argument, absolutely. But proponents of the novel view, the view the EU is relying on, argue that the EU instrument is fundamentally different from a simple seizure.
Because it's temporary and reversible.
Right. And explicitly linked to an international reparations mechanism. They argue it meets the criteria for lawful countermeasures that are proportionate and designed to induce compliance, not to punish.
So they're saying that in this specific extreme case, countermeasures can justify a temporary violation of CBR asset immunity.
That's the argument. The complexity is the defense.
Which brings us to the contrast with what the US and Canada are doing. They seem to have just skipped all this complex management strategy and gone straight for seizure.
Precisely. And you can clearly see the risk the EU is trying to avoid by contrasting its approach with these more direct efforts.
So what have they done?
Canada amended its Special Economic Measures Act to allow for the outright confiscation of Russian-owned property, including CBR assets, and the USA passed the REPO Act.
Rebuilding Economic Prosperity and Opportunity for Ukrainians Act.
That's the one. It explicitly empowers the president to seize, confiscate, transfer, or vest CDR assets to fund the Ukraine Support Fund. And crucially, the REPO Act explicitly invokes countermeasures as its legal basis.
But that's the danger, right? Yeah. And why Russia's lawyers are so interested.
It is. These outright confiscatory measures are final. Unlike the EU's reversible loan proposal, many international legal experts view them as far more likely to violate the international law requirement of reversibility.
Which makes them more susceptible to legal challenges.
Much more. And Russia's response is already in motion. They have publicly and privately threatened extensive retaliatory litigation before international courts, arguing this all violates the principle of state immunity.
And they're not just talking, they're acting.
They are. They have threatened to confiscate Western private capital accumulated in Russia. They've already taken measures to severely curtail Western investors' rights, requiring assets to be sold at, say, a 50% discount. It's kind of soft confiscation.
So this retaliation isn't theoretical. It's already costing Western businesses billions.
Billions.
Which makes the political instability inside the EU even more critical. The internal consensus seems to be constantly at risk.
The external legal risk is immense, but You're right, the internal execution risk is what keeps policymakers up at night. Decisions in this area require unanimity among all member states. That's the primary operational hurdle.
And we know Hungary keeps using its veto power, making the whole structure vulnerable.
Exactly. Hungary has repeatedly blocked or threatened to block sanctions packages, often demanding concessions in return. This creates severe uncertainty. Since these measures have to be renewed every 6 months, a single veto could cause the immediate unfreezing of the CBR assets.
And Russia's claim against Euroclear would be immediately revived.
For the full $210 billion. That's why that legislative move to use qualified majority voting for prolonging the asset freezes is so profoundly important.
It's not just a procedural tweak.
Not at all. It is an effort to stabilize the financial underpinning of the whole loan mechanism and bypass political obstruction. It's a mathematical fortress built to withstand political disagreement.
This whole high-stakes legal and political gamble, it seems to reflect a deeper, more fundamental trend we should explore, the transformation of the European Union itself. The EU seems to be moving away from being a pragmatic, rule-based economic bloc into something more ideological, more of a political entity.
That's a very sharp observation.
And where do we see this transformation most clearly outside of these big political decisions in Brussels?
I think the shift is most profoundly reflected in the evolution of the European Central Bank, the ECB, and the radical expansion of its mandate.
How so?
The ECB was originally conceived as a classical, highly conservative central bank. Its focus was strictly on price stability, modeled heavily on the German Bundesbank. Its primary objective was singular and narrow.
But a sequence of crises has changed that.
Systematically. From the global financial crisis to the Eurozone debt crisis and now to the geopolitical and climate crises. They have all led to a systematic aggrandizement of the ECB. It's now assuming tasks and roles that go far beyond traditional money management.
Okay, let's map this evolution. How did the ECB start out in what you call phase one?
In its initial phase, pre-2009, the ECB operated under a very strict, almost rigid interpretation of its mandate. Its primary objective, right there in Article 127 of the treaty, was maintaining price stability, full stop.
Which is different from the U.S. Federal Reserve, which has a dual mandate.
Exactly. The Fed has price stability and full employment. The ECB's singular focus was rooted in that German historical anxiety angst about runaway inflation.
And its strategy reflected that.
Completely. The strategy was highly rule-based, often called monetary targeting. Policy was strictly inflation-centered. The expectation was that the ECB should be robotic and predictable, just focused on macroeconomic stabilization.
Then came the global financial crisis. That was the first massive structural test, and it forced the ECB to intervene in ways its founders probably never intended.
It was a huge shift. The GFC significantly altered the ECB's behavior. It led to a period of self-empowerment under intense crisis conditions.
So its scope shifted.
Massively. It broadened to explicitly include financial stability as a critical objective. As a direct response, new tasks like banking supervision, the creation of the single supervision mechanism, were assigned to the ECB.
Giving it immense power over European banks.
Immense. And the strategy shifted too. It moved away from strict rules toward what you could call constrained discretion. The approach became stability-oriented, incorporating the idea of leaning against the wind to counteract inflating asset markets.
So it started acting more like an economic stimulus?
In many ways, yes. It was often stepping in and substituting for reluctant government fiscal policy to prevent deeper crises. But even then, this discretion was still primarily macroeconomic in focus. It was about the health of the euro and the banking system.
Okay, so that brings us to phase 3, post-COVID. This is where the institution truly transforms, isn't it? And where the roots of the CBR asset gamble really lie.
Indeed. The post-COVID period and the subsequent crises have pushed the ECB beyond macroeconomic management into broader societal and ideological roles.
What does that mean in practice?
The current strategy has shifted radically to what some call societal-based monetary policy. It's a holistic view-based approach. It's far less about fixed monetary rules and much more about high-level discretion guided by political objectives.
So price stability is still the primary mandate, but the secondary one has grown.
It's expanded dramatically. It's leveraging other treaty objectives, specifically sustainable development and a high level of environmental protection. In the 2021 revised monetary policy strategy, addressing the effects of climate change appeared as a new disruptive objective.
So the ECB is now explicitly factoring social and environmental policies into its decisions. How does that actually work?
It works through a suite of instruments, often called green monetary policy. For example, the ECB has adjusted its collateral framework, giving preferential treatment to assets that meet certain climate targets, or ESG criteria.
So they're pilled winners and losers based on green credentials.
In a way, they are increasingly acting as a consumer of global data on vast issues, requiring climate data disclosure from companies. They've integrated climate risk into their stress tests for banks and have tilted their corporate bond purchases toward issuers with better climate performance.
That's a radical departure from its original mandate.
Completely. And you see it elsewhere too. The Transmission Protection Instrument, or TPI, introduced post-COVID. It wasn't just a technical tool. It had the explicit goal of helping keep the euro area together and preventing fragmentation.
So it's about political and societal cohesion now, not just money management.
Exactly. This profound evolution of the ECB really mirrors the aggrandizement of the EU itself, the struggle over how to handle the CBR assets, creating this legally precarious, high-stakes instrument to achieve a political objective. It fits perfectly into this broader pattern.
So the EU is prioritizing ideological goals over strict adherence to traditional financial and legal rules.
It's the highest, most existential expression of this new, risk-tolerant European political identity.
So we have to summarize the core tension here. The pursuit of a really essential ideological and political goal-punishing aggression, financing reparations, through this novel financial mechanism. It risks fundamentally undermining the credibility of the entire euro-denominated financial system.
That's the gamble.
And the legal architecture, it's designed to minimize the risks specifically to Euroclear, right? Which holds most of the assets.
Right. The immobilization effectively frustrates Russia's claims against Euroclear while sanctions are in place. But the entire financial world knows that the moment those sanctions are lifted, the absolute obligation to repay those cash balances to Russia just revives.
Which leaves Euroclear and by extension Belgium exposed to massive liability.
And the EU instrument serves as a temporary guarantee against that. By transferring that shared responsibility to the EU and its member states, it ensures Euroclear is guaranteed a claim against the EU if Russia defaults after sanctions are lifted.
It's necessary to prevent a financial meltdown at Euroclear,
which is a key hub of global finance. But the global takeaway is much more profound. The EU is attempting to unilaterally rewrite the fundamental rules of global finance on the fly.
They're asserting a new principle.
A new, non-customary principle. That central bank assets are only immune so long as the government operating that central bank behaves in a way the EU approves of. This politicization of sovereign reserves is the core risk. It's the same risk from my friend's dinner analogy, using his house as collateral simply because the bank didn't like his behavior.
So if this whole intricate plan fails, if their legal justification via countermeasures is successfully challenged in court, or if Russia's threat of massive retaliation comes to fruition, what is the precedent set for the euro's global position?
If the legal justification fails, the precedent is devastatingly clear. It says that sovereign assets held in euro-denominated markets are now officially vulnerable to political expropriation, even through complex reversible mechanisms.
And the reliability and safety of holding reserves in the EU would be fundamentally questioned.
By central banks around the world, particularly those countries that don't align politically with the EU and G7 consensus. Think China, India, the major Gulf nations. These nations rely on the absolute legal neutrality of the financial system.
The fundamental concern, then, is the long-term erosion of the euro standing.
It is. We could be seeing a slow-motion process of what you might call de-eurozation. When a state's sovereign assets are treated as conditional collateral based on the foreign policy approval of the host bloc, it encourages other major reserve holders to diversify their holdings out of the euro.
Into assets or jurisdictions they see as safer, more legally neutral.
Exactly. And that creates a long-term credibility deficit that could significantly erode the euro's status as a global reserve currency, imposing costs on the entire eurozone economy for decades to come.
We started this deep dive with the jarring realization that a seemingly clever legal solution to fund Ukraine is also a desperate, high-stakes gamble against established international law and the principle of state immunity. A challenge that Russia's silent army of lawyers is actively preparing to exploit.
And we've seen that the EU's approach, this reparations loan mechanism, is meticulously crafted to ensure temporality and reversibility. It's all framed as asset management, not outright confiscation.
That temporary nature is their primary defense.
It is. It's their shield against the overwhelming customary international law protection that's afforded to central bank assets.
This legal defense, however, is only necessary because the European project itself has transformed. It's moved beyond its original pragmatic economic mandate into an ideological space, mirrored by the ECB's own expansion into pursuing broad societal policy goals.
And the struggle over these $210 billion in Russian assets is merely the most acute existential expression of this new risk-tolerant European political identity. One where a political goal is pursued through novel, risky financial instruments, fundamentally challenging the trust upon which the entire global financial system is built.